about business succession planning and what does a business succession lawyer do and why you may need one and why you may not. If you own a business in Utah, there's one question you must answer before anything unexpected happens. What happens to your business if you're suddenly gone? Not just gone permanently, gone because you retire or become disabled, pass away, or simply decide you're done and you want to enjoy the life you built. If you don't have a clear legal plan, the state, your partners, or even the courts may decide what happens, not you. Hi, my name is Jeremy Eveland. I'm an attorney that regularly does business succession, and today I'm going to explain exactly how business succession planning protects your company, your family, and everything you've worked for. Let's start with the basics. A business succession lawyer helps you plan the future transfer of your business on your terms. Whether that transfer happens because of retirement, death, disability, sale, or passing the company on to your children, the goal is simple. Your business continues smoothly, your family is protected, and your wealth isn't lost to taxes, disputes, or forced liquidation. You spent years building something valuable, and succession planning makes sure that value doesn't disappear when life changes. And life always changes. So, what does a business succession attorney actually do? Well, first, we do buy-sell agreements. That's probably the most important thing. If you own a business with partners or an LLC with other members or a corporation with additional shareholders, you need to have a buy-sell agreement. It's one of the most important documents you can have. It determines exactly what happens to an owner's share if they die, become disabled, retire, or if they want to exit, if they want to sell. Without a buy-sell agreement, ownership can pass to a spouse or an heir who has never worked in the business, and now you're suddenly in business with someone who doesn't want to be there and doesn't know how to run it. A properly drafted agreement prevents that. It gives the remaining owners the right to buy the interest at a fair, predetermined price, no chaos, no surprises. Second, a full succession plan. This is a roadmap for the transition. It talks about who takes over, how it happens, the timeline, and under one condition. So when a full succession plan is done correctly, customers barely notice a change, employees stay confident, and operators continue without disruption. Third, valuation planning. You see, before you can transfer or sell a business, you must know what it's worth. Establishing a clear method ahead of time prevents arguments later and protects everyone involved. Fourth, transfer strategies. Businesses can be transferred in many different ways. They can be done through sale, gradual gifting, installment payments, employee buyouts, or trusts. Each option has different legal and tax consequences, so the right strategy depends upon your goals. What do you want to see happen? Fifth, tax planning. Transferring a business without planning can trigger significant taxes. It can be income tax, capital gains tax, and even estate taxes under some circumstances. Proper legal structures can dramatically reduce those costs and preserve wealth for you and your family. Sixth is asset protection. You see, planning ahead can shield business assets from future creditors, lawsuits, or unexpected claims during a transition. Seventh, coordination with your personal estate plan. You see, business succession lawyers make sure that your will or your trust and your business documents work together like this. Otherwise, conflicting instructions can create delays, disputes, and even court involvement later, and we want to avoid court. Eighth, key person planning. If a critical owner or an executive dies, the business may need immediate cash to survive or fund a buyout. Insurance structures can provide that liquidity instantly. Typically, they're called key man policies, key man trusts, that type of thing. And finally, partner and shareholder agreements. These define voting rights, management authority, profit distribution, exit rules. Without shareholder agreements or operating agreements or partnership agreements in writing, then a single disagreement can paralyze the entire business. And you'd be surprised how many times I've seen partnerships or companies operating without these types of agreements. So here's the real question. Why does all of this matter right now at this very moment? And that's because the risks of having no plan are severe. Without succession planning, a death or disability can freeze operations while the estate goes through probate. Probate is the public court process that can take months, sometimes even years. You see, during that time, family members and partners may fight over control. Business value can drop quickly because of uncertainty. Employees may leave. Customers may lose confidence and go to other vendors. And in many cases, surviving owners and heirs are forced to sell the business at a discount or they close the business down entirely. Every one of those outcomes is largely preventable with a plan. You stay in control. Without one, someone else takes control. So when should you hire a business succession lawyer? Well, it really depends on your business. If you own a business at all, especially if you have partners, employees, or family members that are depending on the income, the answer is sooner rather than later. If you're a one-person shop, you have no family, you're very small, you probably don't need a business succession lawyer yet. But the moment you get a partner, you get shareholders, you get other members, you definitely need to have written documents in place. So this is when you should seriously consider as a business succession plan. If you have co-owners or shareholders, if you expect to retire in the next decade, if you want to pass your business on to family, if you plan to sell someday, if you want to minimize taxes, if you have key employees that are essential to the success of your business, or you simply want to have certainty about the future, then succession planning is right for you. And now's the time to get started. Succession planning is not just for large corporations. Small and mid-sized businesses often have the most to lose because they have fewer resources to absorb a crisis if something happens. Let's talk about what happens without a plan versus with one. Without a plan, an owner dies and the business interest goes into probate. Decisions stall, creditors can file claims, partners may be stuck with heirs who don't want to be involved. With a plan, the buy-sell agreement activates immediately. Ownership transfers according to predefined rules. The family receives fair compensation. Business keeps operating without a skip in the process. No panic, no court battles, no disruption. Good planning makes a transition feel almost routine. Everything just simply keeps moving right along. Another key point is succession planning is not one size fits all. A startup with co-founders needs basic agreements early, and that's probably all they need at the beginning. A growing company needs more advanced planning. They need valuations. They need employee protections. A family business, they must maintain balanced fairness among children with the realities of who can actually run the companies. Owners nearing retirement need funded buyouts and income planning. Complex businesses with multiple entities require coordinated legal, financial, and tax strategies. So whatever stage you're in, planning should match your situation. Now, when choosing an attorney, you want to look for someone who's experienced in business succession, knowledgeable about Utah law, coordination with estate planning, like we've talked about earlier, someone who is able to clearly communicate and have a comprehensive approach, not just a one document, here you go, and you're done. Some of the most common mistakes I've seen include having no buy-sell agreement, relying on an outdated valuation, ignoring tax consequences, failing to fund a buyout, and treating planning as if it's a one-time event rather than something that should be reviewed on a regular basis. Utah law also has specific rules about how ownership interests transfer, especially for LLCs and corporations. So if your governing documents are silent or you have no governing documents, default state rules will apply, and those may not match your wishes. So the bottom line is simple. Your business represents years of sacrifice, risk, and hard work. A succession plan protects your investment. It protects your family from uncertainty. It protects your partners from chaos. It protects your employees and customers from disruption. And it ensures that when you eventually step away, you do it on your terms, not because circumstances forced your hand. So here's what I want you to do next. If you own a business in Utah and you don't have a clear succession plan written down in writing, signed by everyone, I want you to reach out to my office today. Me and my team help business owners create buy-sell agreements, full succession plans, transfer strategies, and we coordinate with estate planning, everything needed to protect what you've built. You can call us at 801-613-1472 for a consultation, or you can click on the link in the description below, fill out an application to see if we're a good fit. We'll review your situation and help you determine the next best steps. Don't wait for a crisis to make this decision for you. Plan now while you still have options. Thanks for watching.